So put those forms out that I need them immediately. Today we're going to talk about the rent cap and just cause eviction law. And the reason we're going to talk about this again, I've talked about this a number of times, but there's a lot of complexity associated with it. So I want to make sure that we go through all the details as a matter of fact. So we're familiar with the form RCJC, rent cap and just cause form, right? And there's two aspects of it. There is a law going back to July 2020, that restricts the amount of a rent increase if you're not exempt to the Tenant Protection Act. And also there are specific reasons only why you can evict somebody if you are subject to the Tenant Protection Act. There are exemptions available. So let's put it this way. Everybody is subject to the rent cap and just cause eviction law. It's also known as the Tenant Protection Act. It's also known as AB 1482. So I want to make sure that we understand all that, but they're all referring to the same law. So in terms of rent increases, assuming you're entitled to the exemption, you can increase rents annually by 5% plus the cost of the CPI. In addition to that, for reasons for terminating a tenancy, there's a list of 15 reasons that those are deemed to be at-fault reasons, and those that are no-fault reasons. And we'll go through that in terms of the detail of that. And also the just cause eviction laws, not rent cap, applies to those tenants who have occupied a property for more than 12 months. So if they've occupied the property for only 10 months, could you theoretically terminate a tenancy without giving a reason? The answer is yes. So exemptions from the rent cap and just cause law. Single family properties and condos are exempted if notice of the exemption is provided to tenants. So the exemption form that we use is the RCJC, and there's a box that indicates that they're exempt. You should be checking that box, assuming you are exempt. The owners on a real estate investment trust, a corporation, or an LLC in which one of the members is a corporation. So individuals many times have LLCs, and if one of the members of the LLC is a corporation, they may not be entitled to the exemption from the rent cap and just cause laws. So meaning you're limited in regards to how much you can increase your rents, and you have to terminate a tenancy based upon one of 15 reasons. If you're exempt from that, you can terminate a tenancy without any reason. In addition to that, you can increase rent as much as you want, but there's always restrictions associated with that. Also, other exemptions from the Tenant Protection Act. If the property is 15 years of age or less, so if a certificate of occupancy was issued within the last 15 years, that property would be exempt. Property that's considered to be a duplex, although the term duplex has been removed from the law as a matter of fact. So a single property in which two individuals can occupy, assuming you as the owner occupy one of the two premises prior to the tenant, you are entitled to the exemption. But at the time that the owner moves out of the property, they would lose the exemption. So they would have to, if they terminated tenancy, can only terminate based upon 15 reasons, or they're also subjected to the maximum rent increase currently of 8% annually. Dormitories, there's an exclusion. So you send your kids to a college in California, they have no obligation to abide by any type of an increase in rents, which is very surprising.
Was it state schools?
Yeah, state schools, USC, UCLA, exactly.
Well,
So,
USC's private.
yeah, if it's either way, if it's a dormitory associated with a institution of higher learning, there is no cap in regards to what the rent increases can be or the reason for termination of a tenancy.
Wow.
And then owner-occupied single-family properties renting no more than 2 bedrooms, including accessory dwelling units. But remember, no matter what, everybody is subject to the law, and you can take advantage of the exemption by providing the tenant with the appropriate form, which is, in our case, a rent cap and just cause notification. The law does not apply to commercial properties. It does apply to personal property mobile homes. It's rare we ever engage with properties that are mobile homes, but it does happen periodically. So if it's in a mobile home park, it is subject to the Tenant Protection Act also. Vacation rentals. Vacation rentals, although not explicitly excluded in statute, typically don't apply. Because if the tenancy is for a period of less or 12 months or less, then the Tenant Protection Act does not apply anyways. So somebody who's renting out a vacation rental property is not facing the same obligation as a traditional landlord.
What about residential commercial, Rich, like 5 units plus, like 10, 20 unit apartment complex?
There is no exemption. So Carlos is saying, so what if the rental property consists of 5 units or more? There is no exemption. Actually, if it's for 2 units or more, assuming the property owner has not occupied one of those 2 units in advance of the tenant occupying the second unit, an exemption is not available to you, meaning you cannot terminate the tenancy based upon no reason. You must use one of 15 reasons. In addition to that, you're going to be subject to the rent cap increase. Currently, it's 8%, and I'll go through those details. But those are complications that anybody has to give consideration to when trying to terminate a tenancy. Johnny had a transaction, or actually just we had a discussion last week. So they have a building that occupies 10 units, or actually there are 10 tenants in the property, and the seller wants to sell the property, but they have one tenant they don't like, and they want to get rid of this tenant. Well, unfortunately, they just cannot terminate the tenancy unless there's cause. It means non-payment, for example, or if somebody is going to occupy the property who's a family member, or if there's going to be substantial remodeling. So there's only very few reasons why you can terminate a tenancy if you're subject to the Tenant Protection Act. And in certain cases, you may not be able to even terminate the tenancy. So that's an issue. So in the event, and I'm going to be going back to July 1st of 2020 in many cases, because what I've experienced, we've come across many leases that have been in effect going back to a time preceding that date. And the question always comes up from my perspective, have we actually given them a RCJC form? We possibly have not. So a landlord may be subject to increasing rents by a limited amount, and also they may not be able to terminate the tenancy for no reason whatsoever. So we have to keep that in mind in regards to what we're doing. So if you have a landlord that has had a tenant for years, they should do one of two things. They need to have the tenant sign a rent cap and just cause form, or they may have to impose that on them through a notice of change of terms of tenancy, but I'll go into the details of that. So if it's a month-to-month tenancy, does that matter? Yes, it does matter as a matter of fact. If it's a month-to-month tenancy and the landlord has never had the rent cap and just cause notification signed, they should be sending that tenant a notice of change in terms of tenancy, which is, and accompanied or attached to that is the rent cap and just cause form, which would then allow them to take advantage of the exemption that should be available to them. And for new tenants, and if you look at anytime you're issuing a lease through ZIP forms, the RCJC is always a part of that packet. So there's no reason to not have anybody sign that, as a matter of fact, and you should always have a tenant sign that. And if it's a 10-unit apartment building, obviously the exemption is not available. So you cannot check the box indicating that the exemption is available to the property owner. So what takes place if a tenant doesn't sign the rent cap and just cause form? So we're issuing a new lease agreement and the tenant refuses to sign that. I wouldn't even consider going forward, assuming the exemption is available to you. If the exemption is not available to you, it's probably not that critical, as a matter of fact. But in no case would I ever accept a lease agreement in which I believe I'm entitled to the exemption and the tenant refuses to sign that, because we're going to be taking away a lot of the rights that the landlord's going to have. So a couple of things. So let's assume we have a new lease agreement, and the lease agreement, can it be signed electronically and delivered electronically? Yes, it can. But let's assume we have a month-to-month tenant that's been there for years, going back to 2020, and they have never signed a rent cap and just cause notification. And now we want to change the status of that month-to-month tenancy. We can do that. All right, so if we have a month-to-month tenancy, what can we do? What if we want to increase rents? We can send them a notice of change of terms of tenancy, right? And increase the rents with a 30-day notice. So we can arbitrarily or unilaterally change the terms of that month-to-month tenancy. And it's the same thing if they have not signed a rent cap and just cause notification form. We can actually send the rent cap and just cause notification form to them attached to a notification of terms of tenancy, form CTT. Thank you, Carlos. And within 30 days thereafter, it becomes effective. It's just like if we want to increase the rents, we send a notice of change in terms of tenancy, 30 days thereafter, it becomes effective. Now, the dilemma is going to be with a notice of change in terms of tenancy, can it be signed electronically by the landlord? No. Can it be delivered electronically? The answer is no, it's invalid. Can we sign a new lease agreement electronically and deliver it electronically? The answer is yes. So there's a big difference. If we're sending a notice of change in terms of tenancy, and that is only going to be associated with the month-to-month tenancies, it must be signed in hand and it must be delivered in a few different ways. I'm handing it to you, post and mail, something like that. Even if the tenant refuses to sign, the RCJC, when attached to a notice of change of terms of tenancy, it still becomes valid 30 days thereafter. So delivery is critical. I'm talking about changing the tenancy arbitrarily versus that of delivering a lease agreement and having it signed. Any questions about that?
Which we'd have to check the box here in section 4, right? Section 4B.
Yes. If we've never had the tenant sign an RCJC, and now we want to take advantage of the exemption, which is always available to us, the box would be checked in section 4, and we would attach the rent cap and just cause notification. But this form, together with the RCJC, must be signed by hand and delivered in a number of ways, which are specified on the change in terms of tenancy. It tells us what acceptable delivery is. If we go down farther, Carlos. Keep going. So it talks about delivery. Personal service by first class mail, posting, things like that. If we deliver it to somebody of suitable age who's not on the lease, we can hand it to them, but we also must mail via first class mail. So there's a big difference when delivering these notices. Mike, you had a question?
If the tenant's been in there for longer than a year and it goes month to month, don't we have to give them 60 days notice when we change the rent? Or
if we want to change the rent, it depends upon the amount of the rent increase. So if the rent increase, let's assume that the landlord is subject to the Tenant Protection Act. All right, so they haven't taken the exemption for whatever reason, or maybe it's not available to them. If the rent increase is 10% or less, only a 30-day notice is required. However, if we've increased the rent during the prior 12 months at any point in time, if the cumulative effect of the rent increase exceeds 10%, then the second increase would have to be a 90-day notice. And if a rent increase exceeds 10% at any point in time, it's a 90-day notice before it becomes effective when increasing the rents for a rent increase, and it's cumulative over the preceding 12 months, which is very interesting.
one more question. Let's say I send that notice via electronic notification,
Uh-huh.
and then the tenant pays the new rent amount for the next 3-4 months, and then says, "Oh, I just read that the notice was supposed to be given by hand or whatever." Does it become invalid again?
Yes, it's invalid.
Even if they started paying the new?
Even if they started paying, so it's void and contrary to law. So that is an issue if the notice isn't delivered properly. They could contest it and they would be entitled to a refund of the difference, as a matter of fact. Yeah, so you can see, that's a very good question, how important that is when delivering these notices. So if it's a month-to-month tenancy and we want to increase the rents, we must have the notice of change in terms of tenancy hand signed, and delivered in one of a few ways indicated on the form, such as personal delivery. And if it's a 10% or less increase in the rents, and that's based upon the lowest base rent during the prior 12 months, it's only a 30-day notice. What is the lowest base rent? So let's assume that during the last 12 months, we had rents of $1,000, and 6 months later, we increased the rent by $100, so the rents were $1,100. So the lowest base rent over the prior 12 months is $1,000. And if, let's assume we increase the rent by 5% after 6 months, so it's $1,050. Then the next rent increase is 5%, of 5% of $1,050. That's what? $1,052.50. Cumulatively, that exceeds the 10% limitation, so that would require a 90-day notice. And delivery, once again, notice of change in terms of tenancy must be hand signed and delivered in one of those manners. But if you're having a new lease agreement signed, everything can be signed electronically and delivered electronically. So when signing a notice of change in terms of tenancy, it must be hand signed. When delivering a notice of change in terms of tenancy, it must be delivered in a specific manner, which does not include electronic delivery. So anything associated with the notice of change in terms of tenancy is all required to be done by hand. Hand signed, and in a sense, hand delivered or posted and mailed or delivered to somebody of suitable age of the property.
So you recommend just doing a whole new lease agreement?
I do. Yeah, you don't have to worry then about it being signed electronically, but you still have to comply with the obligations of the notification period in advance. So if we're going to go from a 1-year lease agreement and we want to increase the rents by more than 10%, we should be giving them a 90-day notification before the expiration of the existing lease that these are the terms under which we're willing to proceed. And then the other aspect is with the fires that have taken place in the Palisades. So now I still think that there is a moratorium issued in regards to an increase in rents. So if it's more restrictive than the Tenant Protection Act, that's going to supersede the Tenant Protection Act. So let's assume that in the Palisades, that the order issued by the governor it's not lifted for 4 years. During that 4-year time frame, landlords cannot issue a rent increase exceeding more than 10% in total for that entire 4-year time frame. So I can see a lot of people who are probably going to be violating those guidelines. A lot of lawsuits, I would assume that's what's going to come under, what's going to happen. And then let's see the rent increase. So let's assume you are subject to the Tenant Protection Act. What can you increase the rents by? Well, it's always 5% plus the consumer price index, which is published. So currently, and it's also the consumer price index upon which we can increase rents is based on a period from April to April. So if I'm going to increase rents by July 31st of this year or prior, I'm entitled to use, or I'm obligated to use, the 5% plus the CPI from April of the prior year. If I want to increase rents the effective date of August 1st of this year, then I would use the 5% plus the CPI issued as of April of this year. But I'm going to simplify that for you. So if I want to increase rents August 1st of this year or later than that, in Orange County and LA, it's an 8% increase, assuming I am subject to the Tenant Protection Act. If I were to have increased rents July 31st or prior to 2025, July 31st, 2025 or prior to that, I was entitled to increase my rents by 8.9%. If I am not subject to the Tenant Protection Act, I've taken advantage of the exemption. There is no maximum amount by which I can increase rents. So that's how critical it is to take advantage of the exemption. And remember, it's cumulative. It's all based upon the lowest base rent during the prior 12 months prior to the date that the increase is implemented.
So you're saying that the first 6 months of the year are based on the previous year's CPI?
I'm saying that August 1st of this year and later, it's based upon the CPI issued as of April 2025.
Mhm.
And I'm also suggesting that if the rent increase was effective July 31st of this year or prior to that, it's based upon the 5% plus the CPI index for April of 2024.
That can get confusing.
Very confusing. So actually, for LA and Orange County, August 1st of this year and any rent increase thereafter, it's 8%. Riverside, San Bernardino, 7.5%. San Diego, 8.8%. And then the prior year, if the rent increase occurred July 31st or prior, then it was 8.9% in LA and Orange County. Riverside and San Bernardino was 9.3%. So CPI has actually gone down. So it's benefiting tenants because it's limiting the amount that someone can increase the rents by, assuming they're subject to the Tenant Protection Act. And then in regards, and that's once again based upon the lowest gross rent. So what if you decide that I have a rent and then I have a pet rent or storage rent? Just be sure that you just specify what the gross rent is, because that's what's going to be based upon. And then if an owner chooses to not increase rents during a prior year, can they bank their rent increase? No, they can't. It's always going to be based upon the lowest gross rent during the prior 12 months before the increase. And then what about if a new tenant is added? Can a tenant or can a landlord increase the rent by any amount that they want? No, they can't. So it's the difference is if someone is subject to the Tenant Protection Act, the only thing they're still subject to the maximum amount of the rent increase. So remember, if you're exempt from the Tenant Protection Act, there's no limitation in regards to how many times or actually the amount of the rent increase that can occur. You just the notice, either 30 or 90 days. But if you are subject to the Tenant Protection Act, and probably most people that have units that are 2 and above, they are not entitled to an exemption. So they're going to be limited in regards to how much they can increase the rents by. In addition to that, how often can you increase rents? If you're subject to the Tenant Protection Act, 2 times a year, nothing more than that. If you allow an additional tenant, then they will allow you to add 2 additional rate increases, but in no case can it exceed the maximum rent increase over the prior 12 months, over the lowest base rent. And what if I have a tenant and I say, hey, I want you to waive your rights in regards to the Tenant Protection Act because I don't have the exemption available to me, and I schedule rent increases in the lease agreement? Is that permissible? No, it's not. You just can't exceed, once again, the maximum rent increase over that 12-month time frame. And then once again, if the landlord from this law is exempt, are there any limitations? Yeah, if there's government orders such as the Palisades where there's restrictions. But once again, if it's the rent increase is 10% or less over the lowest base rent during the past 12 months, it's a 30-day notice. And if I'm going to increase the rent by more than 10% over the lowest base rent during the prior 12 months, it is going to be a 90-day notice. So, and that's cumulative. I think usually we see landlords usually once a year increasing rents, but we've had other instances in which they want to be more aggressive in regards to the increase in rents. And then, so we're going to make the assumption that we are exempt from the rent cap. What properties are exempt from the rent cap? Single family residences, condominiums, so separate alienable properties. Are co-ops exempt from the Tenant Protection Act? And no, they're not, unfortunately, because it must be a separate alienable unit. And with a co-op, you actually own a stock certificate. Also, if it's a TIC, tenant in common, you just own a percentage share, which you can sell. So TICs, the exemption is not available for you, as a matter of fact. If you have a property that's 15 years of age or less, then that property is exempt. Now, if somebody's moving or wants to rent out a co-op and the age of the building is 15 years of less, or 15 years of age or less, then the exemption is available to them. Any questions about that? Okay. And then there's a statutory notice. The statutory notice that must be given to the tenants is included in the RCJC, so I'm not going to be reading that to you. I don't want to do that and bore you to death. And Mike, as we're going along here, I know you had some questions in regards to or leasing properties to students.
Yeah, I remember a couple of weeks ago, the attorney said you can tell them we don't want to take students, but you seem to be a little hesitant about using that as a way to get out of it. But I think Karam kind of cleared it up a little bit.
Yeah, I would say it's completely discriminatory. I do not agree in any way whatsoever. So
Yeah.
it does. And I think, so we have a lot, in a lot of cases, rentals and students are applying for these rentals. So how would you approach that? There's a couple of ways to approach that. You can actually require each student to qualify on their own. So that is a possibility. But then you have to apply that same standard to anybody else who's going to occupy the property. What if it's a married couple? And I told these students, a group of 6 students, that you must qualify on your own. And one of you don't, only one of you doesn't, maybe based on the credit score or the income qualifications, you can then deny credit to the entire group of applicants. But you should be applying that same standard to a married couple or anyone else who's combining their income. So that's something to be very careful about. Likewise with credit scores, if you apply a standard to a group of students, you should be applying that same standard to any other applicants, as a matter of fact. With students, a thought might be that you can actually allow guarantors. And maybe you want each guarantor to have certain credit criteria and certain income that would be applicable. And if they don't meet that criteria, you can deny credit to them once again, but you would have to apply that same standard to any other applicants associated with that rental property. So that's an issue. The one advantage about having a guarantor is the fact that if you look at the lease agreement currently, it limits recovery of attorney's fees and costs to $1,000. However, if there's a guarantor involved, and you can choose any of the guarantors you want to pursue for any deficiencies, there is no limitation in regards to how much money you can recover from them. But if you have a guarantor that's out of state, are you going to spend your time, money, and effort pursuing them? Possibly not. So that's something you might give consideration to, but just whatever you're doing, just as long as you're applying the standards consistently to each and every applicant. And then if you have a tenant that maybe has a lease that's expired and now you want them to sign a new lease, but they refuse to sign the lease with the rent cap and just cause notification. If they refuse to sign that, and the terms of the lease are similar in nature to the expiring lease, you can then deny them the opportunity to proceed. You can cancel that termination. You can say, I'm not going to renew. If you don't sign that rent cap and just cause notification, and we've had instances in which tenants have refused to sign that when renewing a lease, you have no obligation to renew the lease. There's no reason for a landlord to put themselves in that position of accepting an applicant or a tenant or renewing a lease agreement if the exemption is available to them. And then single family properties with a detached grandmother unit or ADU, does that qualify for the duplex exemption? It does not. So if somebody has an ADU and they're occupying a property and they occupy the property prior to the tenant occupying the ADU, the exemption for the rent cap and just cause is not available to them. If it's a duplex, it's available to them. And if I own a duplex and I move in first and a tenant moves in subsequent to that, I'm entitled to take advantage of the exemption to the rent cap and just cause or the Tenant Protection Act. But if I move out, I lose the exemption. Sam, you had a question?
Do you see that changing in the future? Because there's places like San Jose where they're like selling ADUs as separate units now, right?
Well, what I can tell you is that the Tenant Protection Act, it sunsets January 1st of 2030. Now, will it be extended in California? I wouldn't be surprised. There's always these protections that are afforded tenants. So I wouldn't be surprised that it would be extended. Now, is it going to be changed? That's a matter of lobbying your legislators. And I would think if they're going to change it, they're going to make it more favorable for tenants that are occupying ADUs. They're not going to make it more favorable for landlords. Yes.
So any other thing that you can deny a group of students other than the qualification? Because I have rental that the landlord doesn't want to take student because it's a family environment and there's parking issues and for 5 students to have 5 cars, the neighbor is gonna complain and all that. How do you get around that?
Yeah, that's a problem. Well, in terms of the number of people that can occupy a property, California looks at it saying, okay, what are the maximum number of occupants? Because we have a lot of families that seem to cohabitate in properties. So it's 2 per bedroom and 1 for the main living area. So that's one way of looking at it. If you have 7 occupants or 7 people applying, 2 bedrooms and 1 living room, the maximum number of occupants theoretically is 5. So that very well may be a reason to deny them credit. And then when speaking to a student and when they're making that application, I would never suggest anything that we're not going to accept you. I think you just need to be consistent in regards to what the income requirements are going to be and their credit scores. If let's assume one of the tenants, there's 7 students that are applying, and one of them doesn't have a credit score equal to the landlord's minimum mandate, then you would have to issue something called an adverse action notice. So if you have a group of 7 students and the landlord has mandated, my criteria is that each and every applicant have a credit score of 700 and one of them has a score of 500, you can issue a declination, but you also have to issue an adverse action notice indicating the reason for the declination. I hate issuing any type of a declination. So I'm more likely to say that we accept applications in the order in which they're received, and somebody who submitted an application before you met our criteria and leave it at that. And of course, they're going to ask, well, what are the criteria? And you as the agent would say, at least my perspective, I'm not the one who dictates what the criteria is. It's the landlord. So they haven't told me explicitly what the criteria is going to be. We just want the landlord to be aware that whatever their criteria is, that they applied equally to any of the applicants.
But they use the guarantors credit.
You can use, but you have no obligation to accept a guarantor.
Okay.
You can just simply say, but the point is, if you accept a guarantor with one tenant, and then a year later the property is vacant, you accept a guarantor, now your criteria has changed. So you're putting yourself in an awkward position. So you can simply say, we don't accept guarantors. You can do that. That's perfectly acceptable.
It's ridiculous that the landlord has to give a reason why they're not accepting it. It's their house. Like,
Yeah.
I don't need to give you a reason.
I hear stories about agents saying, oh, we don't accept students. I would never say anything like that.
Say of the MLS, there's lender that the credit score only above 750.
If you want to, I wouldn't do that because I think now you're disclosing what your criteria is, and you may want to deviate that from a little bit. But if the landlord is going to adhere to that standard and nothing lower than that, then that's fine. But if you want some flexibility and nothing's in writing, then that might be a way to go by not publishing that type of information. So evictions, let's talk about that. Let's assume you are subject to the Tenant Protection Act and an exemption is not available to you. So we talked about just cause and rent cap. Just cause means the reasons that you can terminate a tenancy or evict somebody. So remember, there's at-fault evictions, non-payment, and then there are no-fault reasons for terminating a tenancy or not renewing a tenancy. So at-fault reasons, non-payment of rent, a breach of the lease, using the property for an unlawful purpose, criminal activity, refusal to allow entry, so I need to get in to repair something. Waste, meaning they're damaging the property, assigning or subletting the property without permission. Also, the tenant has refused to execute a new lease agreement in which the rent cap and just cause notification is attached also. If it's an employee who is provided housing by the employer upon termination of the employment, that's a valid reason for terminating the tenancy immediately. And then no fault evictions. So if I am subject to the Tenant Protection Act and the tenant hasn't, let's assume they're paying their rent all the time, they're not damaging the property, so on and so forth. How can I terminate that tenancy? Well, owner occupancy, I'm going to claim that one of my family members is going to occupy the property, but you need to put that in writing. Unfortunately, the RCJC does include that language. With withdrawal from the rental market, meaning I'm going to sell it. Remodeling, but remodeling must mean that they can't occupy the property for at least 30 days. And if that's the case, you may have to provide evidence of building permits and other aspects if you're going to claim you're vacating the property based upon remodeling, or maybe a governmental order to vacate the property. But if we get to the end of a tenancy, and Johnny's here as a matter of fact, so and we briefly talked about this. His client has a 10-unit building, and the property owner does not want to renew a lease for this tenant, but the tenant appears to not be damaging the property, and the tenant's paying on time. So can we actually terminate the tenancy? Because in a 10-unit building, the exemption from the Tenant Protection Act is not available to the property owner. He can't terminate the tenancy. He can increase the rent. That's something he can do, and maybe that will cause the tenant to give a notion that I don't want to continue living here, but there may be nothing that a property owner can do if they don't have the exemption available.
Sure. But if you increase the rent, surely you have to increase it for everybody. Otherwise,
No, I don't think so.
Isn't that discriminatory? If you just pick on one person, some putting your rents up, everyone else stays the same.
That's a good point. Well, don't bring that up, right? So it's a good point. I never really thought about that. Could it be discriminatory? I'm not increasing anyone else's rent. Probably, yeah. What I would say in this case, the leases are expiring at all different times. So who knows if that could be something that they might claim is discriminatory. But there's nothing that I'm not aware of anything that causes a landlord to treat each tenant differently in regards to a rate of increase. I guess it would all depend upon what the rental rate is. But yeah, that's a good point, Jonathan. That could be discriminatory.
Hey, Richard, I think we can use market condition advisory for that.
All right, so there's an answer. Mike, you had a thought?
So if I wanted to terminate the tenancy early, I could do it if I'm gonna tell them I'm gonna remodel.
You can't terminate it prior to the expiration of the lease, but you give them notification
That you're not gonna renew.
that you're not going to renew, and these are the reasons why. Yes.
If the reason is because a family member is going to move into the unit, and the family member moves in but decides they don't want to live there after 3 months,
The family member must occupy the property for 1 year. And if they don't occupy the property, I don't know if everybody heard his question. If it's terminated based upon the fact that I'm claiming a family member is going to occupy the property, the family member has to move in within 90 days of lease termination. The family member must also occupy the property for 1 year. In the event the family member does not do that, you actually have to offer them the tenancy at the prevailing rate they were paying previously. And if they choose to not do that, you must put the property on the market for the rate at which you are leasing the property to the person that you evicted.
wow.
Richard,
Yeah.
I have a question.
What's that? I'm listening.
Okay, let's say at the beginning, with the terms that decide don't have pets, and they sign for 12 months. In the in 6 months after everything happens, they decide to bring a pet, even though at the beginning, it was agreed that they're not gonna have pets. Is that can be a termination, or what do you do with as a landlord?
Well, so I'm gonna differentiate between the two. If it's a pet and they bring a pet into the property, you can give them a 3-day notice to cure or quit. If they don't, then you can terminate the tenancy. If it is a service animal, and they provide the appropriate documentation, there's nothing you can do.
Okay.
Does that answer your question? So a pet is far different than a service animal. And it seems like everybody that they're smart enough to know how to abuse the system and consider it to be a service animal, that there's a process we can go through to document the fact that whether it is required or not. So that's something that can be used if in the event somebody does that. And what's so common, Carmenza, that we see this all the time, as a matter of fact. People will have a signed lease agreement, and Crom's was probably the most egregious. 20 minutes after that lease agreement was signed, the tenant then indicated that they have 3 service animals, dogs. It's an 1,100 square foot place, and the dogs were 45, 55, and 65 pounds. I remember this vividly. And they needed those. So there was virtually nothing we could do based upon the fact that they were service animals. If it's a pet, then it's a different story. But these people knew exactly what they were doing.
Is a cat considered a service animal?
It can be, sure. It doesn't have to be a dog.
Yeah.
Bird, cat, horse, snake. I don't think there's any limitation.
What is a giraffe?
A giraffe?
What if a person decides to identify as an animal?
Oh my God.
Wow.
What?
Right?
Only in California.
Oh,
No credit check. No credit check required.
no credit check. I am a service animal and I want to occupy your residence. Yeah. Well, Mark, that's one that I have not heard of yet, but I can assure you it's going to happen here, right? See how creative people are? Oh, God, yeah. And then also, what does current law require in terms of the time periods necessary to terminate a tenancy? And which type of notice are you to use? So there are different types of notices to terminate a tenancy. For non-payment of rent, a 3-day notice to pay, rent, or quit. However, if the property is secured by a federally backed mortgage loan, and if you get a loan through any bank, it's federally insured, then a 3-day notice to pay is required, and possibly a 30-day notice to vacate may be necessary. So to terminate a tenancy with someone who's not paying their rent, and there's a federally backed insured loan associated with their property, not only a 3-day notice to pay or quit, but a 30-day notice to vacate most likely is going to be required. Just worse and worse. And then for nuisance, using the property for unlawful purpose, waste, or improper signing or subletting, a 3-day notice to quit. And that's non-curable. So there's nothing they can do once you send that to them. Now, if an employee doesn't vacate the property after they're being terminated, there's no notice required. You just have to start the unlawful detainer action, unfortunately. And then if somebody indicates that I've terminated the lease agreement, must the notice be given in the event they didn't move out? No, you can just start the unlawful detainer action. They have an obligation to move out, as a matter of fact. And then if it's going to be for owner occupancy or a family member, 60-day notice to terminate a tenancy, withdrawal from the rental market, 60 days. But Mike's question, what if the lease agreement has 6 months remaining? You can only terminate the tenancy. You cannot invalidate that lease agreement any sooner than that, unless you maybe had a clause in there that specifies something to that effect. And then for substantial remodeling or demolition of the property, it's a 60-day notice. Let's see, but and here's what I wanted to mention, because the law under Senate Bill 567 really made it very arduous for landlords. If I claim that I am going to remodel, or I want my daughter to move in the property, got to identify the notice, the name of the person and the relationship. And then they have to move within 90 days. And then if it's a multi-unit building, if there's an available unit in there, or they're occupying a unit in there and there's still another available unit, that's not a valid reason then. If they don't move in within 90 days, as I said before, then you may have to offer it back to the tenant that you evicted at the prevailing rate that they were paying previously. So that's a problem. Let's see, there's a couple of other things I wanted to go over. Substantial remodeling. That's another claim people are trying to make. So Senate Bill 567 has tightened that up. So with the notice of termination of tenancy, you must, if the remodel is, let's see, as described, if it's not commenced within 30 days, that's a valid reason which you may offer or may have an obligation to offer the tenancy back to the prior tenants. You have to give a description, you have to provide building permits. So it's very burdensome in regards to any landlord that's making that claim. Obviously, they're trying to prevent you from doing that. And then if I'm subject to the Tenant Protection Act and I terminate the tenancy based upon a reason, let's assume it's non-payment. Do I have to give them relocation assistance? No. But if I want to terminate the tenancy based upon the fact that I want my daughter to move into the property, I have to offer them relocation assistance. And that must be done in two different ways, or must be done, you have a choice. You can write a check to them for within 15 days of the notification. And if you don't do that, then you have an option of just indicating to them that they do not need to pay the last month's rent. And if you don't do one of the two, then the termination of tenancy is invalid.
Rich, is there a minimum amount of TI or improvements that you have to do?
I would say it's probably based upon the fact that if the tenant can't occupy the property for at least a 30-day time frame, then if you're not meeting that standard in a sense, it's probably not a valid reason for terminating the tenancy based upon remodeling the property. If they can occupy the property without it being a health or safety standard, then you have to give them access to the property during that period of time in which it's being remodeled. So those are my comments for today. Any other questions just about tenancies in general? I know we had that one from Mike, which I think is something everybody is facing. And Lynn, you also had the same issue in regards to people that are applying that are students, which is probably the biggest issue. We have a number of people applying as a group and landlords don't want them to occupy the property. So how do we prevent that from happening?
I have a question regarding the credit score. When we apply credit card or something, they always ask you have to have a certain minimum credit score. Why not publish the credit score in our ad for the renting? I mean,
why wouldn't we choose?
Yeah, what's the concern to publish the credit score?
This is what Sarah is asking. Can I actually put that in a private record?
Why not?
You can. However, if you apply a different standard to somebody, let's say you want a 750 minimum credit score, but then you accept a tenant subsequently has a 700 credit score, you haven't followed your own criteria. So now you've discriminated against the prior applicant that didn't meet the credit score standard. That is why you wouldn't want to do that. So you're better off not having in writing.
Consistent, right? I mean,
Exactly.
You insist.
That's really the most critical aspect, okay, as a matter of fact. And once again, if you decline someone based upon a credit score, and that's going to be your reason for declination, you have to issue an adverse action notice.
Oh, really?
Yes.
Oh.
So you have to notify them the reason why you decline them. Okay. And then they have the opportunity to contact the credit providers themselves directly to question their credit scores.
Thanks.
Sure. Any questions about that?
So I guess the only way in my case, and it happens all the time in all my lease listing, the only way is not to accept the guarantor. And require minimum qualification to be met.
For each and every applicant, yes, but just apply that, right? So if you don't want any guarantors, I think that's probably a good idea. You're not going to accept a guarantor, and most likely students aren't going to meet the minimum income requirement.
For like, let's say like you have 5 students apply and all they need is to meet the 1/5 of the rent.
No, you can actually say if your income must be $5,000 a month. Let's assume there are no other students involved. You can say your income must be $5,000 a month, and every student must meet that criteria. But the problem is, if you have to apply that same standard, even if it's for anyone who's age 18 and older, if it's a family, for example, a husband and wife, they should each then have income of $5,000, or at least average income of $5,000 per individual.
Let's
So
say
you can
your
actually,
rent is $5,000.
Huh?
And
The
you
rent's $5,000.
require their income to be 40% of the 5,000.
yeah,
So all 5 of them have to have an income of 40% of the rent.
right. Or if the rent's 5,000, they have, and you don't want their debt to income ratio to exceed 40% of their income, then you would want them to have income of about $9,000 each.
Each.
You can do that.
That's easy.
But for the next applicant, that doesn't, on a per individual basis, for each tenant signing that lease, husband and wife, they also should be averaging the same amount, right? They should each have the same amount of income.
Right. So we need to lower that just to get the family because.
Yeah.
Right.
Yeah, you can see how, difficult that is in regards to applying that equally to a group of students versus maybe somebody who actually wants to occupy the property. That's why I just suggest saying, if we take applicants in the order which are received, and somebody who met our criteria submit an application in advance of yours, and that's the one we accepted. That would be my approach.
And if they're
You can do
counting
that.
money,
Hopefully you have more than one applicant, that's really what it comes down to.
if they're counting money their parents are giving them as income, and we're asking them for last 2 months bank statement to show and
Giving them,
right? I mean, how else are they using money or getting
that
money
I wouldn't,
for rent?
if it's somebody who's divorced and they're getting alimony,
Yeah.
you can justify it as income, but because mom and dad are just arbitrarily giving money.
Yeah.
That is not a source of income.
So then that could
That's
be the
sustainable.
reason, right? Because you're asking for the last.
They don't have any income. That's really what it's coming down to. They don't have any income.
That should be reason enough, right?
Yeah, you can say insufficient income, possibly, if you have to give a reason. I would just look the other way and not give a reason for declining
Right,
them.
right.
Okay, any other questions? No, thank you. Thanks for coming, everybody.
Thank you, bye.
Thanks for coming today. Oh, the drawing, yes, for everyone that's here. Has everybody turned their